Judy Mazo returns to the committee, as does Mr. Macy. She is speaking on behalf of the Multi-Employer Coalition. She is Senior Vice President and Director of Research for the Segal Company, really one of the more renowned and expert pension firms in the nation. Before joining the company, Ms. Mazo was engaged in private law practice in Washington, specializing in ERISA, serving as special counsel to the Pension Benefit Guaranty Corporation, as a consultant to the pension task force of this committee, the Committee on Education and Labor. She was senior attorney for the PBGC and executive assistant to its general counsel from 1975 to 1979. Ms. Mazo speaks and writes frequently on employee benefits matters, is also a member of the Pension Research Council of the Wharton School. Ms. Mazo graduated with honors from Yale Law School and Wellesley College. Welcome back.
As you pointed out, I'm here on behalf of the Multi-Employer Coalition and most especially the National Coordinating Committee for Multi-Employer Plans, the NCCMP, which is the premier advocacy organization for multi-employer plans. Since 1980, I've been a member of the NCCMP's working committee. That was shortly after I served as a consultant to what was at that time and now is again the Committee on Education and Labor, and I'm pleased to be here. The NCCMP, working through the broad group of employers, business associations, multi-employer plans, labor unions that came together as the Multi-Employer Coalition, supported and advocated for the general design and many of the particulars of the multi-employer funding provisions of the Pension Protection Act of 2006. That act made significant changes to the ERISA multi-employer pension plan funding rules, as Mr. Klein has pointed out, which changes that we think will make the plans significantly stronger and position them in a much better way to meet their promises and the expectations of the people that they cover. A major achievement of the PPA was the recognition of the special context of multi-employer plans and accommodating the collectively bargained framework within which the plans operate. The distinctive funding rules for multi-employer plans that are established by PPA will, we think, allow our plans to flourish. We think the opposite would have been the case if multi-employer plans had been simply swept into the new single-employer pension funding rules. That would have been a catastrophe, and it was averted. And Mr. Chairman and Mr. Klein, both of you provided significant leadership in achieving that, and we're very grateful to that. And in fact, as recognition of that, the multi-employer plans don't need a delay in the funding rules the way the single-employer plans definitely do. Before talking about specifics, I do want to mention one overriding principle that we think should guide you all in making policy about pension plans, and that is something that Scott has certainly alluded to, preserving defined benefit plans. Their demise in many sectors of the economy has been widely noted. Indeed, yesterday I thought it was a very good description of what it's like to be a defined benefit plan sponsor. It was one word: treacherous. However, in the multi-employer community, the commitment to defined benefit plans is still strong. We urge you to be vigilant not only to overt threats to the vitality of defined benefit plans, such as the proposal by the Department of Energy to refuse to cover contractors' defined benefit costs, but to much more common subtle threats, which are the unintended results of the 1,000 tiny nicks of regulatory detail. Turning now to some of the 1,000 tiny nicks, specific ideas for statutory improvement. We've put together a comprehensive list of technical adjustments to the multi-employer funding rules that we think will make the PPA work more smoothly if adopted. There are bound to be more issues that are identified as people dig into the implementation. In fact, since we put that list together a month ago, I've already identified 3 or 4 more as they kind of come up. The full list is appended to our written statement. We think they all deserve careful attention, but I'm going to mention just a few to give you a flavor of what we're talking about. It's just an illustration. We're not trying to assign priorities of one change over the other. Frankly, these are technical corrections, so the details can be difficult to follow, and the impact is not profound, except in the way that there's tiny things that could make a difference of many millions of dollars. Also, to all but the most intense benefits groupie, describing them could be very boring. I'm going to try to take a stab at overcoming those problems and giving you a little picture of the kind of thing we're talking about. First is what we call the revolving door for critical status plans. These are commonly known as red zone plans, a terminology very similar to your lighting system. If a plan is in real trouble, it's in red. If it's heading to trouble, it's in yellow, and now I'm in yellow. But the way the technical rules are to figure out whether a plan is in the red zone, there are certain actuarial factors that have to be disregarded. Then they have to be taken into account to figure out if you've gotten out of the red zone, that you could end up tripping over your toes and getting out, and then the following year, because you have to change your calculation, getting back in. We've suggested we think a pragmatic way to get around that. The other one is simplifying the rules governing the benchmarks for yellow zone plans. And bear with me, a plan that trips both measures for being in the yellow is called seriously endangered. Its benchmarks may be different from those of a plain old endangered plan, or they may not be, and how a plan measures up can change from year to year, so the benchmarks can fluctuate from year to year. We've suggested streamlining all of that, ideally boiling it down to one metric so that plans don't meet themselves coming and going.